Hi there, what's new with you? Me, I've just been out seeing a client on their intellectual property strategy, and was reminded again that take a little bit of a heretical view in that particular area. Particularly in the IT space, it's extraordinarily difficult to defend patents, and while it is attractive to do so, it's highly unlikely and extremely rare that people will defend a patent all the way through to completion. So where does that kind of leave you? Copyright is a natural flow-on from what you do. The problem being in IT world that it's far too easy to make the necessary 10 to 15% changes. Apart from that, copy fairly wholesale. So unless you're doing something particularly extraordinary, there's not really a lot of protection that you get at law. Sure, it came up in conversation as it does, the fact that you've got the high-profile lawsuits and patent portfolios owned by, your Apples and your Googles and your Motorola's and Xeroxes, etc. And that's all fine for them, but that's part of their game. That's part of their keeping each other off balance kind of strategy. And for them, if they can have a team of lawyers and put in tens of millions of dollars to keep their opponents off foot for 6 months in the market, well, that's money well spent. But for the rest of us, that's not really an option. So where do we place intellectual property protection? And look, the conversation with this particular client started to look, well, why are you interested in this? Are you trying to keep your competitors out of it? Perhaps you're better off with trade secrets. Perhaps you're better off with a number of different strategies in that area. Are you doing it to support your price and valuation in a potential sale? Because that is one of the things that vendors will, potential acquirers will look at. How are they going to value any patent that you have? How are they going to value your protection? Sure, they're looking for a barrier to entry, but there's a lot more in the valuation of the barrier to entry in your current market hold, in the term of your subscription base, in a whole lot of other factors outside necessarily your intellectual property. It's a fairly blunt weapon to protect. There are hopefully some other more systemic barriers that you have to entry. So if it's not that, again, why are you doing it? Sure, look, there's reasons again in going for government grants and getting support and joint ventures, etc. It looks good. It's one of those ticks in the boxes, and sure, it makes that difference. Look, my advice at the end of the day, and I think this is probably, well, again, I certainly got feedback that it was different from what they were being told from some of their legal opinion, was that yes, indeed, they should take some preliminary patent protection, but not actually do it with an eye to successful legal defence. They should value it, they should invest in it, only in as much value as it was going to give them. It was going to give them some tick in the box for some government funding that they were hoping to go for. It was going to give them a tick in the box for a potential future acquisition, but with the knowledge that their acquirer would value their intellectual property on their own ability to defend it and take a completely different viewpoint, so it should only be seen as a first step, and they should only invest that far along their own lines. And indeed, it should be seen as, for a competitive stake, a matter of really no more than supporting a legal letter or two, approaching your competitors with great anger and gusto at some stage in the future, but really with the full knowledge that there was no way that this thing will ever defend in court. So do it, go through it, but take a fairly cynical view of it, because the chances of you actually winning a legal court case on the back of it are pretty slim. Have fun.